Good afternoon, everyone. It's my pleasure to welcome you all to our webinar this afternoon on protection in the UK, border security, asylum and immigration bill, co-hosted by the Refugee Studies Centre and the Bonavero Institute of Human Rights at the University of Oxford and University College Dublin. My name is Başak Çalı and I'm a professor of international law here at Oxford University, based at the Bonavero Institute. And I specialize on international human rights law. As you would all know, if you're following the recent developments in the UK, asylum in the UK is at a real critical and political juncture at the moment. And our aim in this webinar is to analyze the limits and potentials of this juncture. So following the Nationality and the Borders Act in 2022, the Illegal Migration Act in 2023, and the Safety of Rwanda, or Asylum and Immigration Act in 2024, in the King's speech, it was announced that there's going to be a new bill focusing on immigration and asylum. And recently, the Home Secretary of the Labour government, Yvette Cooper, has announced an end to the UK's migration and economic development partnership with Rwanda. So the new legislation is upcoming, but currently we do not have a full draft, but we have a few ideas about what is going to be potentially included in the legislation. Some of these talking points that are publicly available focus on fast-track decisions and returns to safe countries, and stronger powers to disrupt, investigate, and prosecute organized criminals facilitating organized immigration crime. So I have today with me an excellent panel to analyze this very critical legal as well as political juncture that we're all in. Let me introduce them briefly to you. This will be hard to do it briefly, but I'm going to give it a go in terms of a brief introduction. So on the panel, and also our first speaker is Cathryn, Professor Cathryn Briddick. She's the Andrew W. Mellon Associate Professor of International Human Rights and Refugee Law, and a Fellow of the St. Antony's College at the University of Oxford. She's a scholar of human rights as well as refugee law, and she also works on feminist approaches to international law to analyze protection, discrimination, and the relationship between them. She's published in leading academic journals, including also on the UK immigration and public law, non-discrimination and equality law, European Union law, and public international law. Cathryn's monograph, Arguing Discrimination in Migration Law, is currently forthcoming with Oxford University Press. I'm also joined today by Raza Husain, KC, who's a barrister at Matrix Chambers. Raza specializes in public law with an emphasis on immigration and human rights. He was appointed Silk in 2010 and nominated in 2013 year as Human Rights Silk of the Year, and have previously been awarded Human Rights and Public Law Junior of the Year Award by Chambers Bar Awards in 2007. In 2013, Raza was also listed among the top 100 Silk practicing in all fields at the UK Bar. Raza has appeared in an impressive amount of cases before the UK Supreme Court, as well as before the Court of Justice in Luxembourg and the European Court of Human Rights in Strasbourg. He's also advised and was instructed by the United Nations High Commissioner for Refugees. And perhaps something quite relevant for our webinar is that he was the lawyer of the appellants in the AAA and others case before the UK Supreme Court. I'm also delighted to be joined today by Yasmine Ahmed. She's the UK Director of Human Rights Watch and brings 2 decades of incredible experience as a public international lawyer and human rights advocate. In her current role as the UK Director of Human Rights Watch, she advocates for the United Kingdom's foreign and domestic policies to be consistent with human rights. And prior to Human Rights Watch, she was Executive Director of the multi-award-winning human rights organization Rights and Security International. She has also worked for the UK and Australian governments, and she started her career supporting asylum seekers and refugees in Australia. Finally, I'm joined by Professor Cathryn Costello, who is Professor of Refugee Law and Migration at the University of Sutherland School of Law at University College Dublin. She was formerly Professor of Fundamental Rights at the Hertie School in Berlin and also former Andrew W. Mellon Professor of International Refugee and Migration Law at the Refugee Studies Center at the University of Oxford. She's a leading scholar of international and European refugee and migration law, and also explores the relationship between migration law and labor law in her scholarship. She's the author of Human Rights of Migrants and Refugees in European Law, and also co-editor of the Oxford Handbook of International Refugee Law and Migrants at Work, Immigration and Vulnerability in Labor Law. An outstanding panel, a very important and a very critical juncture. So we will proceed as follows. First, my panelists will speak about 7 minutes, and their first aim is to set the scene in both UK law and international law and the current policies and practices surrounding asylum in the UK, also in the light of international law and European law surrounding these matters. Following this, I will have a very brief follow-up question to all my panelists, and then we are going to be very happy to open the floor for questions and discussions, which you will be able to use the Q&A function of this webinar to pose your questions. And we will be able to take them as written questions, and I will try to make sure that we get as many as possible before the webinar ends in about an hour. So I'm absolutely delighted to welcome my panelists and all of you to this webinar. And without further ado, I'd like to give the floor to Professor Briddick. Over to you, Cathryn.
Thank you very much indeed. Now, the UK's obligations to refugees and those in need of international protection are determined by a range of legal sources, including treaties and customary international law. At the international level, the UK has signed and ratified the 1951 Refugee Convention and a range of other instruments that prohibit refoulement and protect rights. These include the International Covenant on Civil and Political Rights and CEDAW, the Women's Convention. At the regional level, the UK is bound by the European Convention on Human Rights, as well as allied conventions on violence and discrimination against women, the Istanbul Convention, and the Trafficking Convention. And again, these offer protection and rights both from refoulement and in some cases to a form of regularisation. Now, the UK is primarily a dualist jurisdiction. That means that we differentiate between national and international law, and we require the incorporation of the latter into the former for it to be domestically enforceable. And if you're interested in this, there's a fantastic article in ICLQ by Lord Justice Laws exploring the UK as a primarily jurist regime. Very practically, the European Convention on Human Rights was incorporated into domestic law through the Human Rights Act, but there's been no parallel direct incorporation of the other instruments that I have referred to, including the Refugee Convention itself. Instead, the UK purports to meet its international obligations to those in need of protection through an agglomeration of primary legislation, the immigration rules and policy. And this agglomeration is as Byzantine in its complexity as it is Kafkaesque in its contradictions and its cruelty. Now, in characterizing UK immigration law in these terms, I am not engaging in academic hyperbole, but quoting judges who have had to interpret it, because almost each year in the past decade has brought with it a new piece of primary legislation concerned with immigration. And there have been innumerable statutory instruments and statements of changes to the immigration rules. The rules themselves are well over 1,000 pages long, confusingly ordered and extremely poorly drafted. And here I'm drawing on the work of the Law Commission. Changes made following the UK's departure from the European Union have compounded a degree of complexity that give rise to quite significant rule of law issues. If, however, we focus on post-Brexit changes, it's possible to discern two phases in the previous government's approach to protection. The first we might characterize in terms of reinterpretation and criminalization. Here, the language is of fidelity to international law, even as its meaning is distorted. So with the Nationality and Borders Act, for example, we see elements of the refugee definition and substantive trafficking protections being rewritten in ways that diverge from both the wording of the relevant instruments and their objects and purposes. We also see the introduction of criminal offences in relation to arrival and entry into the UK, which are contrary to the refugee protection from penalisation, and which have resulted in refugees being prosecuted and imprisoned. Parallel to these developments, we've seen the introduction of so-called bespoke schemes for particular groups of people: Ukrainians, some Afghans, those who hold a particular kind of British nationality and who are from Hong Kong. Now, these all have different and complex eligibility rules, and they bestow different packages of rights. And in the main, these packages of rights are less beneficial that go with refugee protection. Now, I'm framing this in terms of reinterpretation and criminalization because they're often, or they were, offered as justification for these moves, as if offering some people protection and rights enables you to deny those very things to others. Now, the second phase, built on the first, but can better be characterized as an attempt to extinguish asylum and repudiate our international obligations. Here I'm drawing on the language of UNHCR. The Illegal Migration Act, agreements reached with Rwanda and then legislation on that country's safety, sought to externalize refugee protection, preventing asylum and trafficking cases from being determined in the UK, and requiring instead detention and deportation to Rwanda. Now, Raza is going to speak about this in a few moments, but I do want to take a moment to say that the fact that this did not occur was because of the commitment and the tenacity of lawyers like him, the legal teams involved, and UNHCR. Now, following the election, we're entering a third phase, and I want to highlight some positive developments and some developments of concern. First, the decision to end the Rwanda scheme, which cost £700 million and goodness knows what in terms of human suffering, the government's renewed commitment to the European Convention on Human Rights, the gutting of the Illegal Migration Act in a statutory instrument, processing protection claims, and finally the decision to transfer the sovereignty of the Chagos Islands to Mauritius. These are all indicative, in my mind at least, of a government that's committed to the international rule of law. And some of these developments were unthinkable just a few months ago. I think it's worth remembering at this point that the Safety of Rwanda Act only received royal assent at the end of April this year. We are, however, as Başak has explained, looking at another piece of legislation, the Border Security, Asylum and Immigration Bill. And statements on this indicate that the newly created Border Security Command is going to be endowed with new counter-terror style powers. These being matched with fast-track decisions, return to safe countries, and an increase in the detention estate. Now, it's hard to subject these commitments to scrutiny other than to observe that the use of anti-terrorist powers or rhetoric in this context is profoundly worrying and wholly inappropriate. And in a different vein, you don't need primary legislation to process claims faster or to seek to negotiate a returns agreement with the EU. So this is a moment that calls for a reset and a substantive engagement with the international and regional instruments I started a few moments ago by referring to. So what might such a reset entail? Now, I have three suggestions which I'm going to group in terms of law, process, and access. In terms of law, a reset would involve a repeal of legislation and particular provisions that depart from our international obligations to refugees and to victims of trafficking. Now, this would include the entirety of the Legal Migration Act and the Rwanda legislation, but it would also include significant aspects of the Nationality and Borders Act, and perhaps I'll come back to this in a moment. Alongside this repeal, there needs to be a concerted attempt to address the complexity that I've described. And here, a useful starting point remains the Law Commission's quite old, but nonetheless very helpful work on simplification. Second, on process. Yes, we obviously need faster decision-making, but the focus should be on the quality of the decision-making, and it needs to be matched with a commitment to publicly funded legal advice and representation. One thing that the Home Office could do here is take an approach that's been endorsed by UNHCR and adopted in countries like Finland and Sweden, and that's conducting group determinations of particular people who we know meet the refugee definition, such as Afghan women and girls. Third and finally, access. The bespoke schemes, criminalising entry, attempts at externalisation, and reference to counter-terror style powers, these are all responses to what I would say is just the wrong question, that question being, how do we stop people arriving? A reset on access might involve asking a different question, one that acknowledges that people are both going to seek and, crucially, receive asylum from persecution in the UK, and asks, therefore, how might this be achieved in a way that respects the rights and dignity of all of those involved? Thank you.
Thank you. Thank you very much, Cathryn, for also bringing us to start thinking about what are the potentials with the new bill. Let me turn to Raza Husain, and also have a discussion in relation to the current state of play before courts and the most recent judicial decisions in relation to the existing legislation and legal frameworks.
Thanks very much, Başak, and thank you very much to Cathryn, Briddick, for organising this and for inviting me to speak. It's a delight and privilege to do so. I've been asked to speak about various aspects of the AAA litigation, which, of course, as you'll know, concerned the previous government's Rwanda policy, under which asylum seekers arriving here via a third country where they could have claimed asylum would be removed to Rwanda, where their claims would be processed by the Rwandan authorities, and if granted, they would enjoy refugee rights there. This was unprecedented as a matter of policy in UK history. It was the first time, as far as I'm aware, that an asylum seeker did not have to have a connection, an EU law requirement, with a safe third country to which removal was proposed. In ad hoc cases, previous governments had tried to do this, for example, the Saudi cleric al-Masri in the 1990s, but never as a matter of policy. The policy was upheld by the divisional court, although individual decisions were quashed, found unlawful by a 2-1 majority of the Court of Appeal, and again found unlawful in more emphatic terms by a unanimous Supreme Court on the basis that it gave rise to a risk or unacceptable risk of refoulement. I want to focus on 5 areas. I won't talk about Article 31 because Cathryn Costello, we're very lucky to have Cathryn talking about that. She's a clear expert on the point and has written fantastically on it. First area, non-refoulement. No doubt, in response to the furore about Article 3 of the European Convention stopping the UK from being able to control its borders, the Supreme Court went out of its way to underscore the fundamental importance in public international law of the duty of non-refoulement, holding that it was a core principle of international law, citing Article 33 Refugee Convention, Article 3 CAT, Article 6 and 7 ICCPR, as well as Article 3 of the European Convention, and observing that it may also be a customary norm, citing the 2001 Declaration of State Parties Refugee Convention, which in its 4th preambular recital refers to the principle of non-refoulement, whose applicability is embedded in customary international law, a statement that is repeated in the UN General Assembly Resolution 57187, adopted by consensus. Indeed, a week or so before the hearing, the Swiss Legal Office has said that it amounts to a jus cogens norm, as recognized, for example, by the Cartagena Declaration, Colombian Constitutional Court. And surely that is where the debate lies. That is to say, whether it's a peremptory norm or simply a customary norm, notwithstanding whatever very eminent and influential legal positivist academics might say on this area. So the principle of non-refoulement has been recognized as a norm of customary international law by the ICC, the International Criminal Court, ICC, and Canadian Supreme Court, Court of Appeal, New Zealand. Supreme Court also pointed to 4 domestic acts which gave effect to the Refugee Convention, picking up on Cathryn's theme. This is being done in a slightly hodgepodge manner, as well as the ECHR, and which therefore protects asylum seekers against refoulement. So that's the first point, the fundamental importance of non-refoulement, both in domestic law as a matter and international law. Secondly, the approach to assurances. This was a case where the safety of Rwanda as a third country depended upon the reliability of assurances it had given the UK. Government's assessment was that given its reputational and financial incentives, the Rwandan government would abide by them, despite the evidence that there were serious systemic defects in their procedures and institutions, and despite the fact that the Rwandan government had a history of acting in breach of the principle of non-refoulement, including in the context of a very similar arrangement with Israel. The government claimed that its assessment commanded great weight and deference. Divisional Court agreed, recognizing the expertise that resides in the executive to evaluate the worth of promises made by a friendly foreign state, giving 3 reasons why the Secretary of State was entitled to rely on the assurances: well-established relationship, the terms specific and detailed, and there was witness evidence from a senior official of the SPDCO that the government was confident that the obligations would be honored. The Divisional Court said that it could only go behind that opinion if there were compelling evidence to the contrary. Importantly, the Supreme Court held this was a mistaken approach, contrary to Strasbourg and indeed Supreme Court authority, Ottman and Zabolotny, the Supreme Court held that the court had to make its own assessment of whether the substantial grounds for believing wasn't required, real risks to exist, wasn't required to accept the government's evaluation of assurances absent compelling evidence to the contrary. And that's very important in the context of courts evaluating these sorts of arrangements if they emerge again. Third area, the importance of UNHCR's role in evidence. Divisional courts' view that the evidence of the UNHCR carried no special weight was a further error, as the Supreme Court found. A number of factors meant that it was entitled, to be given particular significance. 4 points, really. First, UNHCR's constitutional responsibility, its status, its entrustment by the UN General Assembly with supervision of the interpretation and application of the Refugee Convention. Secondly, its institutional expertise generally. The courts had recognized the unique and unrivaled expertise of UNHCR in the field of asylum and refugee law. Thirdly, expertise in a particular case. It had unrivaled practical experience of the working of the Rwandan asylum system through long years of engagement. And fourthly, the fact that its submissions were presented with moderation didn't appear to reflect a partisan assessment, despite the fact that it had an institutional position on the policy, as Cathryn has said. So those factors meant that it was entitled to particular importance. Again, an important matter here. The fourth area I wanted to look at very quickly was the government's approach, relatedly, the government's approach to the UNHCR. The UNHCR was excluded from the information gathering process on Rwanda, despite official acceptance that it alone had access to the vital information regarding that process. It first heard of the policy when it was announced on the 14th of April 2022, and the MOU was published. The first it heard of the note verbal, where all the practical detail lay, the devil really was in the detail, was in court when the first interim relief hearing was being heard. The government had claimed in decision letters that the policy had the imprimatur of the UNHCR, a claim it was forced to retract and apologize for. The government failed to disclose meetings it had had with the UNHCR after the announcement of the MOU until midway through the first interim relief hearing, 10th of June 2022. You'll recall that the flights were scheduled for the following Tuesday, the 14th. And this was the disclosure only happened when UNHCR raised the fact that they had occurred. So this was how the litigation had been conducted in the early days. Fifth, what happened next was, I think, an understatement to say, would be an understatement to say constitutionally troubling. And so in order to stop, as it was said, spurious claims challenging the policy, no doubt like the claims that succeeded before the Supreme Court, the government introduced a bill which Parliament passed as the Safety of Rwanda Act 2024, to which Cathryn referred, which I think is, without question, the most draconian and rule of law non-compliant legislation that there has been. People I've spoken to in the House of Lords agreed with that. So a combination of Section 1 deeming a fact, deeming Rwandan safety notwithstanding the Supreme Court's judgment, on the basis of further developments at executive level, government to government level, so deeming a fact on such a central question, judicial review, ouster in the most nuclear and comprehensive terms of the central question. I'll stop there. I'm over time and come back.
Thank you. Thank you very much, Raza. We'll definitely come back to what we expect. Also, from the courts, perhaps after a new bill is introduced, which we don't know the full details of as yet. So let me give the floor to Yasmine Ahmed now to perhaps also talk about questions around access and perhaps other issues that you'd like to raise, Yasmine, about the current state of play and where we are before we walk into a new legislation.
Yes, thank you very much. It's obviously it's an honor to be on a panel with such esteemed people, and thank you for hosting this. Really appreciate it. So I think from where we sit at Human Rights Watch, and particularly in the UK, it was over the last number of years, I would say over the last sort of 3 to 5 years, we saw the last government systematically dismantling and undermining the international protection, as has been outlined already by the speakers before me, and particularly Cathryn. This was done in a systematic way, in an incredibly egregious way, with a number of pieces of legislation. And each piece of legislation we thought could not actually get worse, but in fact did. And obviously it's already been discussed, the fact that these pieces of legislation, the Nationalities and Borders Act, the Illegal Migration Act, are still on the books, which is deeply worrying. And we have not heard from this current government that they are going to repeal those pieces of legislation. And as has been noted, these pieces of legislation fundamentally undermine the very premise of the refugee architecture, was the ability for people who are seeking protection to claim asylum, to not penalise individuals who come and seek asylum on the basis of how they have arrived or where they've arrived from, and also the very fundamental principle upon which the refugee architecture is established, which is the principle of responsibility sharing. And we're obviously seeing that principle being undermined not just by the UK, but globally. And I think really importantly is thinking about what the flow-on effects, because this system is a global system, and if one country or two countries shirks their responsibility, it places more responsibility on others. And what we see internationally is that countries within the region of those that are fleeing and seeking asylum are the ones that host the majority of asylum seekers and refugees, countries that have the lowest GDP, and yet countries that have the highest GDP are putting up borders, walls, and externalizing their responsibility. And we saw the impact of that, where we see, for example, Pakistan, that hosts millions of Afghan refugees, are saying returning refugees to Afghanistan, and clearly the impact that countries like the UK and other European countries and the US have on countries that are hosting millions of refugees. And they see that they're shirking their responsibilities and also violating and undermining the refugee convention, and then how we can call on those countries to do the same. And I think just, to speak a little bit about what this means in practice, it was only last year that I was in an event speaking to a diplomat from a country, from Malaysia, in fact, and she said to me, now when the UK government comes to Malaysia and talks about taking in refugees from Rohingya refugees, we just laugh at them, because how do they have any moral or legal or other authority to do that? But obviously their actions undermine the architecture more generally. Then we obviously had, as has been, Raza has clearly explained, we had the Rwanda scheme, which was incredibly pernicious on every level and undermined protections and the scheme, the architecture as well. And we saw that the Supreme Court, as he's noted, found it was unlawful. There was a clear risk of individuals who were sent to Rwanda being subject to risk of refoulement, and then the response of the government, rather than complying with what the Supreme Court has said, was to try and legislate over that and legislate away the facts and the law, the international law. I think this new government, what is this new government's stance? I think there are some really good things they've done. And as has been said, they have come in with a very clear message of we're a government that's coming in and looking to comply with international law and demonstrate our commitment to comply with international law. And they have done that in some regards. They repealed the Rwanda deal. They have made a commitment also to ensure that they're going to, that people now can actually claim asylum. They're going to process asylum claims. They're trying to clear the backlog. But what is concerning about this government's approach is that it still seems to be centered so squarely around deterrence and securitization at the expense of actual solutions and of the international protection regime, which we all know was established after the Second World War, when there were people in need of protection, and yet there is no sense now at the forefront of the government's policy, which we would have hoped, which is about actually saying there are these responsibilities we have and rights of people to claim asylum, and we're going to set up a system that provides for that and works in an effective way. I think we have seen some concerning also developments with speaking about the fast track return systems, which obviously we're very concerned have inadequate safeguards, and the fact that we still don't have proper and sufficient safe routes for people to come to the UK. In terms of, we've seen why do people leave their countries? We know why people are leaving in fear of persecution. People are leaving for a number of reasons, economic or other reasons. And we know that a securitized approach does not deter people. In fact, just makes it more dangerous. This year has been the most dangerous year on record to date of deaths in the Channel. I think it's in 2024, it's 50 deaths already in the Channel. And so I think we know the reality is people are not going to stop seeking protection, are not going to stop seeking asylum, and are not going to stop moving. And the government needs to be taking an approach that takes account of that, and the fact that a draconian securitized approach doesn't make actually anyone safer and doesn't actually, provide adequate solutions. We've seen also the government, unfortunately, the last government, adopting a two-tiered approach also to refugee protection. We saw the approach it took towards Ukrainian refugees, where there were two schemes immediately set up in the UK. We saw the EU establishing and activating the temporary protection rate scheme, and they are very, very welcome. But what we've failed to see is any other schemes set up for example, those that are fleeing the Middle East, including, as we know, what the situation that's happening in Palestine now. And also those that are fleeing Sudan, for example. And we know that the ad hoc schemes that were established have been ridden with problems and have not operated effectively, including the Afghan scheme, which continues to have problems. Whilst it's better than nothing, it's still, there's significant problems, and we can speak to that. I want to briefly end, I know I've run out of time, but I wanted to speak a little bit about the Italy-Albania agreement and say that this was done in November 2023, and I'm not going to go into it because we don't have time, but I think there are very worrying issues around a scheme that essentially provides and does provide for externalization, and the issues that arise and the human rights concerns with such a regime include with respect to onboard screening of individuals as to whether they will be returned to Italy or sent to Albania, age assessments, the fairness of asylum procedures if people are sent to Albania, and the fairness of procedures there, the conditions designated as countries that are designated as safe, such as Egypt and Tunisia, detention conditions themselves, and oversight and appeal processes. We have seen the court in Rome, in fact, on the 18th of October, blocking the detention of 12 asylum seekers from Bangladesh and Egypt on the basis that the migrants' countries of origin could not be designated as safe. But like what the UK did, we're now seeing Italy trying to legislate around that, which is extremely problematic. We know the UK and a number of countries continue to look at these kinds of deals and continue to look at ways of externalizing their responsibility. And we do have concerns about the way and the extent to which UNHCR are involved overseeing some of these deals and these programs, and also programs that they themselves or systems that they themselves are proposing, given the ongoing human rights concerns and the concerns around undermining architecture. So I'm going to leave it there. There's a lot to speak about. I'm sorry I've probably gone over 7 minutes, but thank you.
Thank you. Thank you, Yasmine. So let me also turn now over to Cathryn to also talk a little bit about the penalization and non-penalization we've started having a little bit earlier as well. Over to you, Cathryn.
Thank you all very much, and thank you to the Refugee Studies Centre and the Bonavero Institute for bringing together this great panel with not only people I admire so much as scholars and activists, but my favourite people in general. So I think when we take a wider view, international protection seems to me increasingly fragmented and differentiated. And when we assess its workings, I think we always have to keep in mind these three core dimensions. The question of access, which everyone has mentioned in one way or another. The question about recognition processes, which can so easily undermine protection if the right people don't get recognized. And then the whole question about rights and solutions, the status itself and what it accords people. And I see greater fragmentation and differentiation in all of those three zones of or dimensions of international protection. But perhaps that's nothing new. The Refugee Convention itself has Article 1D, siloing Palestinian refugees and rendering their individual refugeehood conditional on the international communities determining the collective fate of the Palestinian people or failure to protect them. And more generally, we know from the best available political science, and here I'm thinking particularly of the work of Lamis Abdelati, that states have always responded to refugees with discrimination and delegation, treating them differently, sometimes outsourcing their protection to international organizations like UNHCR. So given that we know this, how should lawyers respond? And some legal scholars respond to this vision of differentiated protection, really questioning whether in its entirety, it undermines international refugee law rooted in obligation. That's a view that has been very well expressed recently by Cathryn Doverne. And my view is different because I posit a different relationship between international law and politics, where I think the role of law and legal institutions is to establish a principled framework. And in the context of international protection, I think there are three key principles. We've heard about non-refoulement, and we've seen it play out to great effect in the Rwanda litigation. I think, as I've written with Başak and Stuart Cunningham, non-refoulement is really a huge part now of the case law of the UN treaty bodies, and we get very new and exciting applications of the non-refoulement principle. I think the question of jurisdiction, which is the core question that's going to determine access issues, is subject to really exciting determinations by the UN treaty bodies. There's an important case called Sherlock in Australia about visa determinations and discrimination, which opens up the question of legal responsibility for how visas are processed, something that human rights courts have avoided. So I think when we look at the principled framework, non-refoulement is certainly part of it. And as Raza said, with Michelle Foster, I've also written that, in my view, this is a principle ripe for recognition as a norm of Nius Kogan's. That's a view that has also been endorsed by Professor Deirdre Tlade, who's now judge of the International Court of Justice. The question is, what do we do with non-refoulement? And we can't build an entire system of protection on non-refoulement alone. That just simply says don't send somebody back or send somebody elsewhere if their bare, minimum framework of human rights are going to be imperiled. So we need at least some other principles. And for me, at least those principles, and these are minimal principles, minimum standards, are non-penalization and non-discrimination. And non-penalization is in the Refugee Convention, and I'm very pleased that UNHCR has, in September, issued its guidelines on international protection number 14, based on some work that I did with Yasmine's colleague Emily MacDonald and with Yulia Joffa and others in the past. And I think that the idea of non-penalization in the Refugee Convention is all that states in 1951 were willing to agree in saying, yes, we're going to have a world of migration control and we want to protect refugees. And it was self-evident that then there had to be an accommodation between migration controls and refugee protection. And this very minimal protection is just saying, well, don't penalize refugees for irregular entry or stay under certain conditions, and the provision is relatively limited. it has been historically the British courts that gave some of the most globally important rulings on the content of non-penalisation. It was Lord Bingham in Afzaw described the principle as one of the 3 core principles underpinning the refugee protection, along with non-refoulement and the status and rights that refugees are due. But again, with Julia Joffe, what we've tried to argue is that non-penalisation is a principle of wider import, and that it applies also to victims of trafficking and also to those who have been smuggled, that the system of international, transnational criminal law that bears into the migration control arena is not meant to penalise the migrants themselves. That is, those who are coerced to move, victims of trafficking, or even those who willingly avail of the services of smugglers. That our conception of the reach of criminal law is not supposed to bear down on the protection seeker or even the person moving voluntarily, for that matter, if they're in a vulnerable situation. And I think that addition to the scholarship has been picked up within by the UN Special Rapporteur on Trafficking, for example. And to my mind, this is, a minimum requirement if you're not going to have access to asylum, legal routes for access to asylum. That doesn't mean that legal routes for access to asylum wouldn't be a good idea and aren't legally required under some situations. And I think although there have been many big losses when people have tried to litigate very directly safe access to asylum, when that's gone to the Strasbourg court, the Luxembourg court, I think there's still many good legal arguments to be made about legal access to asylum. Non-penalisation gets us some of the way, but I think access is also important. The final point that I wanted to pick up on is really expanding out the non-penalisation discussion. So as I've framed it, and taking non-penalisation as originating in Article 31 of the Refugee Convention, it doesn't directly speak to the question about smuggling or trafficking, for that matter. It's about protecting the refugee on the move. But of course, we have gotten to a position where we take it almost for granted that smuggling is wrong and warrants criminalisation. And that fundamentally requires a rethink. The activity of assisting somebody in crossing a border irregularly may be life-saving. So it is under some circumstances, it is not an act that warrants criminalisation, nor is the border crossing itself under many circumstances. And unfortunately, as James Hathaway identified at the time the smuggling protocol was adopted, a wide criminalisation of smuggling is antithetical to refugee protection. And I really hope that at some point we can just revisit the fundamentals here, because the smuggling protocol is a protocol about transnational organised crime. What has happened in both EU law and in domestic law in many countries is that it has been a pretext for the criminalisation of all manner of assistance, not only in border crossing, but also in irregular stay. And this, for me, is just, basically a distortion of the appropriate role of criminal law in a liberal democracy. And there are legal ways of pushing back. And with Stefano Verula, I've written about some of them. There's an important pending case before the Court of Justice of the European Union in a case that used to be called Kinshasa and now called Kinsa. So I'm happy to share some material on that, and I'm happy to speak about it a little bit more. And I look forward to the discussion. Thank you.
Thank you very much. Thank you very much, Cathryn. So we have quite a few coming up. There's a disturbance. Is it just me hearing it?
I can hear it as well.
Okay, so hopefully it will stabilize shortly. So, but before we go on to some of the questions that we're also having from the audience, I just want to give everyone a couple of minutes really to reflect on the following. One of the things that has really emerged from all these 4 interventions is that currently we are in a very I think it was Yasmine who put it, sort of things got worse and worse and worse, and one couldn't imagine it was getting worse, and it got worse. So the state of protection in the UK is in a very, very negative place at the moment, both with the practices and the legislation. So there is a particular risk in that sense. If there is a little bit of improvement, we might think that this is fantastic, you know, that it's not as bad as it was, you know, just a couple of years ago. So I'd like to kind of not go in that route, but I'd like to ask you a kind of a more visionary question. So not sort of what should stop immediately kind of question, but one of the things about the current government's manifesto and also its Attorney General's speech on the rule of law that was delivered, for example, on the 14th of October, promises a very strong return to the rule of law, and also talks about a leadership role for the UK, not just returning to rule of law domestically, but also internationally. So in the light of this, what are the things that you think should figure in a progressive legislation? So it's not just about resetting the quite a lot of the issues that was very clearly underlined here, but what are the things that should be in it? And perhaps, you know, we will, if you have a moment to reflect on whether you think we will be able to get to such a progressive legislation, you may also want to comment on that. Who would like to kick off on giving a bit of a vision to the legislatures on this issue, rather than just stopping the worst of the worst practices that you have very clearly outlined?
I can give a very narrow vision, which is, and it's a half answer to one of the questions that we have, which takes your point about the Attorney General's comments on respecting the rule of law internationally and incompatible legislation. I think some of the reset, as I've said, is repealing, but I think we also need to have to go back and visit some sections of the Nationality and Borders Act which didn't attract quite the attention that they should have done, because that legislation was passed against the backdrop of an attempt to externalize protection. And here I'm thinking in particular the new statutory interpretation of what is a well-founded fear, what a particular social group is, the rewriting of protections for victims of trafficking, and then the criminalisation measures that we started to allude to here. These are all things that both need to be repealed as a starting point, but then offer the opportunity for a more progressive approach. And particular social groups is something that I research and that I'm very interested in. And there was a very brief moment before the Nationality and Borders Act, but after the UK left the Common European Asylum System, where we saw a number of very progressive determinations of particular social groups, particularly in relation to things like issues around a person's mental health, ending gang violence, where the UK courts went back to taking a much more simplistic and much more straightforward approach to the PSG, which was based entirely on immutable characteristics. So moving away from having to have the two elements of the test that EU law required us to, which was immutable characteristics and the social perception test. And these are really thoughtful upper tribunal decisions. That some of them are country guidance cases. They review the evidence, they review the legal history to the drafting of the particular social group and its application across a number of jurisdictions. And it shows that the courts, when freed from that very restrictive legal framework, were able to offer much more progressive interpretations of PSGs, much more rights protective interpretations that benefited individuals who, for example, were at risk of gang violence or who had mental health problems, which made them vulnerable to various forms of persecutory harm. So for me, my vision is it's a limited one, and it's one that involves repealing, replacing, and then in some ways enabling courts to apply the Convention's definition in the principled way that they have shown themselves able to do on a number of different occasions. Thank you.
Thank you. That was fantastic. Yasmine, I think you, let me call on you.
Yeah, I think, look, I couldn't agree more with what Cathryn was saying. And I feel that what was particularly pernicious about the way that the last government approached this, and I know we're talking about moving forward, but it wasn't just about introducing laws that, you know, on their face were clearly in violation of international conventions and norms. But what really worried me, and you mentioned, Cathryn, you're working with my colleague Emily McDonnell, who I work very closely with and have on these issues, was seeing the way that the government was also, and we see this also now happening within the EU, of trying to rewrite the norms, to undermine and dilute them. So it's not just we're actually going to, on the face, be in violation of them, which I think in some ways is easier for us to manage. The more difficult and pernicious is, as countries and as communities of countries, we're seeking to actually agree on diluting those norms, whether it be around the thresholds for interim measures, the thresholds for, particular. And I think we need to be really worried about where we're going forward with, and where the EU and others are looking at in that regard, whether it's around externalization or other things. But in terms of, let's look forward and what can this government do? It's a government that's committed itself to international law, to being a bastion of international law. I think the first thing, as Cathryn noted, is that they have to repeal the legislation that's on the books. It just has to happen because it's pernicious and it's problematic, and there are provisions in there that need to go immediately. But what does it look like going forward, and how do you develop them? First of all, they need to be committed to shifting the narrative around migration. We've allowed the narrative of around migration has become so pernicious and instrumentalized. And I feel deeply that it's this government's responsibility to be talking about migration and about asylum in a positive way, and thinking about the way that asylum seekers and migrants have built our country, and the responsibilities that we hold also as a former colonial power to those individuals as well, but also talking in a positive way. Migrants, refugees have built us. We are a society, a better society because of it, and we need migration. We need people coming to this country. And in fact, thinking about the importance of where these obligations came from. And I would want to see a government saying, we accept the right of individuals to seek protection. That is a fundamental right that was born out of the Second World War and out of the horrors of the Holocaust. But also, in addition to that, let's think about how we develop safe routes for individuals to come to the United Kingdom. As we've talked about, people from Palestine, Sudan, places where we know that there is intense conflict, persecution more broadly. There should be routes for individuals to come, and the routes have been ad hoc, have been insufficient, and we need to see a government being responsive to that and creating that. I think we also want to be thinking about, as we've talked about, we need to be thinking about this is a global problem. And when countries consider continually to see this as their issue and about putting up borders and walls, none of us are ever going to be able to respond to what is always going to be something that is a global responsibility. So I would want to see the UK government working collectively with other states rather than undermining it. But how do we collectively have responsibility for this? I think also we would want to see, for example, small things like people who are seeking asylum also having the right to work while their asylum applications. These are simple things, and the majority of people in the United Kingdom are supportive of that, and these things would be incredibly progressive and important. So, I mean, for me, this is not just about repealing or individual measures. This is about an entire narrative shift. And if this government's truly committed, I would say there are a few issues where the rubber hits the road for this government on its commitment to international law, and migration is at the very top of that. And so their commitment needs to be seen, not only seen to be, but to be clearly evident in the context of migration and asylum.
Thank you. Raza, please. Yes.
Thanks very much, Başak. I mean, I think just in terms of envisaging what a progressive policy should look like, I think we should start by saying that there are, in my view at least, there is a sort of fairly hard dichotomy between what we in the UK, along with most of the developed world, have done in terms of access to asylum, and something that Cathryn is very rightly concerned about, and rights delivery. And I think that the score on rights delivery, particularly when courts have been allowed to do what they should be able to do without legislative interference, here at least, has been pretty good. Cathryn talked about a particular social group. It's Fauna, Lord Bingham in Fauna, who said, look, these conditions were disjunctive, not conjunctive. And so that's an example. I spoke at the Institute of Advanced Legal Studies with Hugo Story, and I said that codification is always a bad thing. I can't think of a single good experience with codification of the Refugee Convention. It's always a race to the bottom. Even Matthew Davis's question, even the CEAS, yes, we should rejoin it. It would be good because you wouldn't have abominations like we've had in the last 3 years. Every year, the worst piece of legislation, 22, 23, 24 in the area. But even the CAS, if you look at who is a refugee under the CAS, it's a third country national, not a Hungarian, not an EU national. There's no Article 31 protection in the CAS, and so forth. So even that's not perfect. But broadly speaking, I think that we've done pretty well in terms of refugee rights. But it's, and I agree what Cathryn is saying about the codification in the 2020 Act, but it's really access to asylum, which is just absolutely horrific. It's horrific. And people, I mean, I think lawyers get it, perhaps. A lot of people don't. We're a signatory to the Refugee Convention, a state party. But we are allowed to do everything possible to stop people getting here. It's something that Simon Brown said in Nadimi, one of the first cases on Article 31, to which Cathryn was referring. So my wish list would be, blue sky thinking would be, access, respect access, have safe legal routes as complementary, not replacement, immediately repeal the 2022 Act, which I think the two worst aspects of that Act, and at the time I wrote an opinion with Eleanor Mitchell and Jason Podjoy, saying that it was the worst piece of legislation that the UK had ever had on asylum, only to be sort of completely outdone the next year, as Yasmine said, which again was outdone this year with the Rwanda Act. But the two worst pieces in the 22 Act, I thought, were this two-tier, the creation of a two-tier refugee status based upon direct and indirect access here, basically between rich and poor refugees. And secondly, the criminalization of arrival. And historically, we'd always had drawn a distinction between entry and arrival. The Act abolished that, criminalized arrival irregularly with a maximum sentence of 4 years imprisonment, and didn't even enact a Section 31 defense. Section 31 is a domesticated, inadequately domesticated equivalent of Article 31. So yeah, that would be my wish list, as well as read Joseph Caron's.
Thank you. Cathryn, I'm going to give you a little bit shorter time because I have a couple of questions that I also want to ask you that we've received from the audience. Do you want to say your top three for a progressive policy beyond repealing a question that I think we've covered very well in the previous discussions?
Yeah, so maybe just, I think the first thing would be some genuine leadership from a party of the center left, because I think there's such a vacuum on the left about the politics of migration. And obviously the Labour Party is also the current instantiation of party of law and order. And this criminalization vibe around migration is still the dominant one. And so where is the voice that's going to push back against that? And that could be Yvette Cooper. I mean, she's somebody of sufficient intellectual caliber and intellectual courage to take on that role within the cabinet. But I think there's such, and when I say that there's a vacuum, I think that's not only in the UK, but across Europe and even across the global north, that parties on the left don't have a way of talking about migration that doesn't fall into protectionism or framing migration as a threat, both to domestic workers or to just a threat in general. Then I think on the access part of the equation, I agree that, safe access to asylum is vital, but I think in that what we often lose sight of is the problematic nature of carrier sanctions and that we haven't had them for that long. So the reason somebody can't get on the ferry from France to the UK is a legal problem, not an infrastructure problem. And so and that it has not always been thus. When carrier sanctions were first introduced, UNHCR pushed back very hard against them and tried to get carriers more concerned so that companies would push back against being border control agents. And I think there's some proper intellectual labor to be done, a proper business and human rights analysis about the role of private carriers in migration control that would be worth pursuing and could be practically helpful. So I suppose that's two things: intellectual leadership, thinking about private responsibility in migration control, because that's why sea crossings are deadly. It's nothing to do with unseaworthy crafts as such. You know, this is an illegal market of our own creation. So yeah, and then maybe thirdly, just a bit of an evidence base, you know, from migration studies, from former colleagues of mine in Oxford. We know a lot about how different forms of migration control work, don't work, sometimes backfire, sometimes don't. Our former colleague Heinda Haas did a huge project on this called DMIG. And none of that evidence base informs policy in this field. We have policy based on rhetoric and a punitive dehumanization of protection seekers, and no attention to what we know the evidence base is about which policies work and which don't, and how they're prone to backfiring. So a bit of an injection of an evidence base would make a huge difference if we want to fundamentally rethink this kind of vicious cycle, I think, that we're in terms of you know, wanting to suppress mobility, that backfiring, more people engaging in dangerous routes, then that becomes a pretext for more suppression and so on.
Thank you.